ACUS is a small, independent, nonpartisan agency in the executive branch, the mission of which is simply to help make the government work better. And our statute tasks us with doing that by improving the fairness and accuracy and efficiency of federal administrative agency procedures and processes. The Assembly, which is a large part of the conference, is a 101 member body composed of 50 representatives from government agencies and dozens of academics, legal practitioners, and other experts in their fields, in the fields of administrative law. That is the body that actually debates and amends and votes on the ACUS formal recommendations that some of you may be familiar with. And those recommendations are directed at the federal agencies themselves, to the president or to the Congress, and often to the judiciary as well. We also regularly publish research reports, studies, source books, reference guides, and hold forums just like this one today. This is an opportunity for us to hear from some of those experts as they discuss recent work and research on nationwide injunctions and what the future of such injunctions might look like, particularly in light of the Supreme Court's decisions at the end of last term. A little bit of history that ACUS has on the subject of national injunctions specifically. In 2020, ACUS brought together leading commentators and judges and other public officials to address arguments actually for or against use of nationwide injunctions and universal vacatures as well. And to look at and suggest possible areas for judicial or statutory reform. Since then, ACUS commissioned a study to examine how these remedies affect federal agencies administering their regulatory programs. For our panel today, we'll hear from the ACUS consultants who did the research and wrote the report, and they will discuss that with us. That report was released in June, just a few months ago, and is available on the website. Also available on the website shortly after this panel is completed will be the video of the entire thing. So I'm going to end with a sincere word of thanks to our panelists and to our staff who worked so hard to bring this panel to you and make it happen. And a special thank you to ACUS Senior Fellow Alan Morrison, who is presently a professor at the George Washington University School of Law. He's still very active litigator from that position. And he's someone who's just had a remarkable legal career and has been a longtime friend of ACUS and is very active in our work. So Alan, thank you for holding this conversation, and I turn things over to you.
Thank you, Andy, and thank everybody for attending. Today, we're going to hear about the real-world problems that national injunctions have caused, at least from the perspective of the agency. And we're pleased to have the three authors of the report that Andy mentioned to talk to us about it today. I'm going to turn it over to them. Very brief introductions. We're going to begin, and the panelists are going to appear in this order. Zachary Clopton, who is a senior associate dean for research and intellectual life at Northwestern University Law School, or is also regularly teaches arbitration and civil procedure. And I was pleased to see that he is on the Civil Rules Committee. So I now need a friend on the Civil Rules Committee. I hope I've got one there. He'll be followed by Jeff Stieglitz, who is a associate dean for academic affairs and a professor of law at Cornell Law School. He will be followed by Mila Sahoni, who is now at Stanford Law School. She used to be at the University of San Diego Law School. And I confess, we tried to get her to come to GW, but the West Coast was too much of an allure for her. And so we did not succeed. So without further ado, you don't hear from me. Zach, you want to take it off? Talk about our definitions and the basic questions that the report dealt with.
Absolutely. Thank you so much for the introductions, and thanks everyone for coming. So I thought it would make sense to start by just saying a little bit about the context for this report. So this report addresses what some people call nationwide or national or universal injunctions. And there are some debates about definitions, but I think a rough definition that encompasses what we were focused on in this report are injunctions or potentially other types of remedies issued against federal government defendants that seek to enjoin the government with respect to non-parties without regard to where they're located. So the prototypical national injunction is a court order barring the federal government from applying a particular policy to anyone. Despite the label national or nationwide, most of the debates around these injunctions have not been about the geographic scope of the injunction. I think it's fairly well understood that a federal district court has the power to order a party over whom it has jurisdiction to take actions outside the boundaries of that district. Instead, these injunctions and related remedies raise several interrelated legal issues. So first, there have been big debates about whether federal courts have the authority to issue universal remedies at all. These debates primarily focus on the Article 3 powers of the federal courts, though one could imagine other constitutional arguments such as challenges under the Due Process Clause. Relatedly, there have been what you might think of as a kind of a subspecies of these challenges, which go not to the constitutional power, but instead go to the power of federal courts under the Administrative Procedures Act. The question in those situations is whether the APA authorizes federal courts to set aside or vacate regulations issued by federal agencies, not just with respect to the parties, but again, with respect to all parties, so universally. One thing, by the way, that we may touch on later today is whether agencies perceive a difference between a universal remedy under the APA versus a universal remedy issued in the form of a preliminary or permanent injunction. Finally, another legal question, which maybe hasn't been at the forefront of the kind of high-profile debates around nationwide injunctions, but I think, in fact, exists in every case in which a nationwide injunction issues, is the question about the proper scope of relief in a particular dispute. So even if it were established that federal courts had the constitutional and statutory authority to issue universal remedies, nobody thinks that a universal remedy is going to be appropriate in 100% of cases. Instead, every time a court is asked to make a decision with respect to the remedy, the court is going to want to think about what remedy is appropriate. Is a universal remedy appropriate in this case, or is a more narrowly tailored remedy better? Another thing we might touch on today on this score is how agencies think about the scope of relief. And to give a little preview, one of our findings in the report is that agencies struggled more, I think, with a lack of clarity in the scope of relief than on the universality. Finally, I wanted to say a quick word about what the stakes are, what the consequences are in the choice between universal and non-universal remedies. And that choice, I think, has both direct and indirect consequences. So directly, universal relief should protect not just the named plaintiffs in the case, but would, in theory, protect all persons within the scope of the injunction. So, for example, if a court concludes that an immigration policy is unconstitutional, a universal injunction would order the government to not apply such a policy to all persons, whether or not they were named plaintiffs. There's also a potential indirect effect on the choice between universal and non-universal relief, or multiple potential indirect effects. So one is about the litigation landscape. It's conceivable, for example, that once a universal injunction is in place, we would not see a percolation of other cases because plaintiffs who might file in other districts or other circuits would see universal relief in place and not need to bring additional cases. Though in practice, we have seen examples of multiple suits proceeding, even when a universal injunction is issued. The other indirect effect, which was of particular interest to us in this study, is whether the specter of universal relief might affect agency behavior at the front end. Will agencies behave differently in a world where courts can universally enjoin or set aside their actions, as compared to a world where an agency understands that plaintiffs must seek individual or at least class-based relief against an agency policy?
Zach, can I ask you one quick question, which is, did you consider situations in which the original action is filed in an appellate court, such as EPA or OSHA, and stays are sought there? Is that part of your study as well?
Absolutely. And I think that the legal questions that I flagged would exist in situations where there's a channeling statute to a court of appeals. There's still the Article 3 question, there's a potential statutory question, and then to the extent that a court of appeals is in the first instance crafting relief, they'll have to consider the appropriate scope of remedies.
Thank you. Jed?
Great, let me just load some slides here. Okay, so I'm going to talk briefly about some of our quantitative findings. Our study was basically divided into two broad sections. One in which we investigate quantitatively over time what has been happening with these forms of universal relief. And the second one, which is actually the bulk of the study, is a qualitative study where we interviewed, with AGUS's great help, a series of officials from agencies and probed their thoughts about universal relief. So what I'm going to do briefly in this quantitative review is to talk about both of the main forms of universal relief that we thought about and that have been debated recently. First, of course, nationwide injunctions, and to look at within nationwide injunctions, has the frequency been changing over time? What are the rates of the grant rates, and are some agencies more affected than others? And look at that quantitatively using some large legal databases. And the second section of this quantitative discussion kind of follows the first, but instead of looking at nationwide injunctions, we're going to look at universal vacatur. Okay. So the objectives broadly of this quantitative section are to provide context for the qualitative study that is about that Mila will talk about in just a moment. Is the concern about nationwide injunctions increasing over time? Was there support for that in the data, for instance? One question we were initially interested in thinking about. And it also helped us figure out which agencies we wanted to speak to, because it may be, in fact, was the case that some agencies are much more affected by these forms of universal relief than others. The limits of this quantitative section, I just want to quickly highlight, are a couple. First, we are focusing only on on these two specific forms of remedy. That is the nationwide injunctions, and then also the universal vacatur under Section 706 of the APA. To investigate those two specific forms of remedies, we had to in turn rely on specific search terms. So, for example, we limited attention to cases that actually cite Section 706 when thinking about universal vacatur. And when thinking about nationwide injunctions, we used a few specific variations of nationwide injunctions. So to the extent that judges, as they may not always be, are not always using those exact terms, those will escape from our findings. But again, in part because our main interest, or one main interest, was in trying to guide and give context to which agencies to focus on in the qualitative study, unless those kinds of, you can think of it as errors, are disproportionately affecting some agencies rather than others, this will give us a good sense of who are the agencies, which are the agencies that are going to be of most interest to think about qualitatively. Another limit is that we're relying on humans here. So essentially, the method is to identify cases using these large legal databases, and then task research assistants with annotating them or coding them. And so with any human endeavor, there are going to be limits on their time, limits on their focus, and limits in their judgment. Okay, so now the results. Have nationwide injunctions been increasing? Yes, by the search terms and the like that we use, the grants have been increasing over time. In fact, if you look at the sort of we looked at essentially all time, but the number of cases that actually use this term are very, very few before Clinton. So we are only showing essentially starting with the Clinton administration. And you can see here visually that just the incidence of nationwide injunctions is increasing quite dramatically over time, especially since the later years of the Obama administration and into the Trump administration. It's also the case that the proportion of nationwide injunctions that are granted, that is, assuming this is something that is litigated, what's the rate at which courts are actually granting nationwide injunctions? That appears to be increasing over time too, at least if we're judging based on the Trump and Biden administration. So historically, the grant rate was something around 40%, as you can see from this figure. And here we're just aggregating all the cases that arise in our data set by administration and looking at what are the rates at which the grants were given in these different administrations. And you can see the rate of granting increases during the Trump administration, and that seems to have sustained, at least in the first parts of the Biden administration, which our data cover. It's also the case that certain agencies are much more effective than others. This is not, if we look at the number of nationwide injunctions that are granted against agencies, DHS, for example, is a leader really in an agency that is far more effective than other agencies. USDA, HHS, and DOJ, which is often a party to these cases, is another major agency affected. Okay. We can also look at the rate at which specific agencies are winning. So is it the case, here we're asking, is it the case that some agencies are just always losing and so other agencies are just always winning when a nationwide injunction is at issue in litigation that they're facing with respect to a rule? And what this figure does is plots the number of injunctions granted against the number of injunctions denied for each agency in the data set. And the 45-degree angle is this a line of perfect correspondence, so that if the number of denied and the number of granted were identical for an agency, it would be right on the line. The agency would appear right on the line. And that would indicate that they're batting about 50% or 500. You can see that most agencies cluster something around that line of perfect correspondence, except for, again, DHS, which appears to lose more often than they win. But generally, they're batting about 50%. We'll turn to universal vacatur. We can ask kind of a mirror set of questions. The proportion vacated over time appears a little bit more stable, at least with respect to Obama and Biden. We're looking both there about 50% at the time they're winning when it comes to 706 challenges. But Trump appears to be less successful than both Biden and Obama. And that's consistent with others who have looked at similar data and found that the Trump administration fared pretty poorly under 706 relative to other administrations. If we look at the number of vacated agency actions, this is a sample of cases involving Section 706 and set aside. We can see that the number of cases is disproportionately affecting some agencies rather than others. So HHS, EPA, Department of Interior, DHS, these are all like highly affected agencies. And this will be a function both of the way that the agencies are treated and the number of rules that they're issuing. So just by virtue of issuing a lot of rules, you could appear in this data set. If we turn to the question of, well, are some agencies in fact faring worse than others? Here again, this is a mirror plot of the one I showed with respect to nationwide injunctions. You can see that that the number of vacators granted is above 50% for most of these agencies, but they cluster around the 50% mark. So I will stop there and turn it over to Mila.
Jet, can I ask you a question?
Yes.
The audience,
Yes.
obviously, the president is not subject to universal vacator because he doesn't issue rules under the APA. But in practical terms, what is the difference between a national injunction and a vacator in terms of what the agency can and cannot do, or is there really no difference? It's just the way the case comes up. Some of them are rules and some of them are not.
So our objective in this project generally, and in particular in the quantitative section, is to focus only on rules. So these are, in theory, these should all be rules or rule-like actions. Why they are, it's a good question. Why are some of these arise as 706 actions and others as nationwide injunctions? That's a deep question we didn't really get into in the, we didn't assess litigation strategies as much as we looked at the effect of these decisions on agency behavior, agency thoughts, agencies' processes. And one of the themes that our project did reveal is that the way the agencies seem to process these various remedies doesn't seem too different in either case. And Neil will get into this. I don't want to steal too much of our thunder, but in either case, they're treating this as kind of like put the pencils down kind of situation, and they seem to be in good faith, trying to stop all the activity related to the underlying action at issue.
So any differences we saw in those graphs you gave us, it doesn't suggest a difference in treatment by the agencies beyond the formality of whether something in a rule is vacated or just enjoined from being put into place.
Yeah. So we don't have evidence that the agencies would be behaving differently with respect to those two.
That was the only question I had. Yeah, because they show up twice, and I wanted to be sure that we're on the same page on that. Okay.
Yeah.
Mila.
Great. So I'm just going to talk a bit about the qualitative portion of our study. And just to get our motivation for doing this out on the table, a lot of the scholarship and research into this subject had focused on the courts and whether courts can or cannot issue such remedies, the consequences for the court system, for the shadow docket, etc., of having these orders be out there. And our goal was to kind of take the other side of things and to look at how agencies view, understand, implement, and respond to orders with universal effect. And I'm just going to use the term orders with universal effect to cover the nationwide preliminary injunction, the nationwide final injunction, the universal vacator, and the stay of a rule under 705. And we're just going to call them all orders with universal effect. So to tackle this subject, we conducted semi-structured interviews with a number of officials at nearly a dozen agencies, and we also sent out written surveys to agencies asking them questions. And I'd like to say here at the outset that we are so grateful to the agency officials who spoke with us or who took the time to respond to those surveys. We know that they have severe demands on their time, and we really appreciate their sharing their insights with us. And we're also very thankful to the ACA staff who did the hard work of coordinating all of these various meetings. So ultimately, we conducted Zoom interviews with officials at 11 agencies: USDA, Department of Commerce, Energy, EPA, FCC, the Office of the Federal Register, HHS, HUD, Interior, DOJ, and the IRS. And the people we were speaking to were primarily members of the agency's offices of general counsel. We received responses to our written surveys from FTC, GSA, MSPB, NLRB, and NRC. It's important to note that we were unable to secure interviews with every federal agency that we approached, and there were 5 that declined to participate in our study. And that limitation means that we found what we found, and that's informative, but we don't purport to capture the full range of agency experiences with orders with universal effect. So in our interviews and through our surveys, our goal was to try to elicit information on how agencies interpreted and implemented and responded when they received orders with universal effect. And to encourage candid responses, we offered our interviewees the option to speak off the record and also to move on or off the record for specific parts of the interview. We worked from a sort of fairly standard outline for each interview, but then we moved with the interviewee's conversation, and we followed up afterwards if we needed additional detail. For each agency that we spoke with, wherever it was possible, we tried to use examples of specific cases that had involved that agency, ideally recent cases, to make the discussion more concrete and tangible. So, for example, for a given case in which, let's say, a nationwide injunction had issued, we would ask the agency officials we were interviewing, how did they respond internally when they got word of that order? We would ask questions like, how did you instruct your personnel to comply with or implement the order? We would ask if you, the agency, had experienced any difficulties in complying with the order and what those difficulties were. And we also asked hypotheticals, would you have responded differently had the order been of a different formal category? For example, if the order had been a universal vacatur rather than a nationwide injunction, is there anything you would have done differently? If this case had involved a certified nationwide class, would you have responded differently, and so forth along those lines. And then last but not least, we also asked more general questions. For example, has the uptick in orders of universal effect or the uptick in nationwide injunctions, has that caused you to adjust the types of regulatory actions that you're taking, or has it caused you to change the content of your regulations in any way? So that was kind of how we went about this task. And now, just for our findings here, we did find that the agencies on the whole gave similar responses. We did note some differences in our report. And generally speaking, in terms of compliance, I'll just talk about compliance with these orders. What we heard from agencies generally is that orders with universal effect did not always pose problems for compliance. For nationwide injunctions, one interviewee commented that an injunction against a rule simply means it may not be enforced. Another noted that it may be less complex and challenging to implement such an order than to implement narrower relief, especially when the underlying agency action is nationwide. One factor that seemed to make a difference is how many staff or officials at the agency were affected. Sometimes orders can be, the more agency officials are affected, the more agency staff, the more challenging the implementation, as you would imagine. And another factor that seemed to affect how agencies responded was whether the order itself, the court's order itself, was clear or unclear. And I think, as Zach alluded to at the start, what we heard in these interviews is that the lack of clarity in orders was more problematic, seemed more problematic than their universal or nationwide scope. So several agency interviews flagged the difficulty that was created by ambiguity in the wording of orders, and emphasized the need for clarity. The agency's interviewees thought that clarity was important, both to ensure that an agency knows that it's compelled to follow the order, and also so that the agency doesn't accidentally violate its terms. As one official commented, I'm more focused on the clarity of the decision than the nature of the court order. I don't want to get sued again. From an agency perspective, this is a practical question. So I'll just stop there, and I'm happy to take any more detailed questions.
Let me ask you a question about this clarity aspect of it. When I was an assistant U.S. attorney many years ago, oftentimes you'd see, and when I was litigating against the government, oftentimes you see very different approaches to the actual form of the order Some judges and some courts have a practice under which they make a decision and then they ask the parties to submit an order, in which case, obviously, the agency would have a better chance of participating. Whereas if the judge just simply issues the order without any form of focus on what the order is in light of what the decision is, it's harder to get clarity. Did you have any sense of whether there's a front end problem in that at all with these agencies or not?
So if by front end, you mean, do the agencies, are they submitting proposed orders? Is that the front end?
Yes, or participate in what DOJ submits as a proposed order, or are they just sort of taking what the other side gives and the judge gives? And
Yeah.
whether that's a possible way in which some of this clarity could be improved.
Right. So we did speak with agencies about how they worked with DOJ, and they described themselves as playing a kind of client role, or sort of I suppose a subject matter expert role, and in helping DOJ as it litigated these cases. And so I don't know if we specifically asked about crafting DOJ's requests or for as to the proposed order, but I think in the context of that ongoing consultation about a case, we would expect that an agency would express its views on the proposed relief. I think we did have agency officials comment that having briefing as to remedies is valuable. I think we had at least one say that judges are that going back to a court and saying, here's the consequences, the concrete consequences of order A versus order B can sometimes result in an order that an agency is more able to live with ultimately. And Zach and Jed, please do jump in.
Yeah,
Okay, please go ahead.
Thanks. Yeah, I think that's exactly right. And one of the maybe unintended consequences of the increasing salience of universal relief is that agencies are now aware of the possibility of universal relief. And we heard from some agencies, and we can see as we continue to follow these cases, that agencies in the DOJ are more likely to brief the remedy up front, knowing that the scope of relief is likely to cause a problem down the road. And a couple of high-profile injunctions with somewhat challenging scope, I think, have really drawn attention to this issue. And so my guess is that many folks who are listening, many folks in Agency General Counsel's office now will, as a matter of course, brief potential remedy upfront to avoid these clarity problems on the back end.
And did you encounter any difficulties or put it this way, when an order comes down, it's a universal injunction of some kind, what is the respective role of DOJ attorneys and the agency attorneys in figuring out what should be done and what has to be done and what doesn't have to be done?
Yeah, so what we were told, as one put it, when an order comes in, the first thing you do is put pencils down, right? Pause, figure out exactly what the order means, and then how to go about implementing it. Generally, agencies worked with DOJ to figure that out. We had a couple of rare instances where I think OIRA was also, right, Jed, was it Zach, was it OIRA or OMB, where the order involved multiple agencies, and so they were also looped into that process. But then the agency then decides how it's going to communicate within the agency how to comply with the order, and that can occur in a variety of different ways depending on the particular context. A communication through a listserv, an internal memo, a high level sort of briefing with different officials. The subsequent steps for sort of disseminating instructions varied depending on the particular case we were talking about and on the particular agency that we were speaking to.
Could you say a little bit of a word about the multiple agency issue that you mentioned just briefly, and how that complicates matters?
Yeah, so we talked about a couple of cases where where the specific order affected a large number of agencies. I think the one was the federal government's employee vaccine mandate. And another one was, I think, a case involving a prohibition on, was it diversity training? In both of those instances, the agency, we were interviewing an agency and talking about these cases, but that agency was just one among many agencies affected. And it was DOJ and the sort of coordinating agency in the center that really took the lead role in responding, in guiding agencies on how to respond and how to implement that order.
Right. The third example that we had, I think, goes to both of the prior two questions, which was the social cost of carbon injunction, which both affected multiple agencies, and at least in its first iteration, was thought by many of our interview subjects to be one of these unclear, hard to understand injunctions, that it was unclear exactly how that injunction would affect the operations all the way down throughout the agency, not just in the general counsel's office, but individual government employees and contractors working on issues far from DC that maybe in some way or another were implicated by the injunction. So that was one where both a lot of internal coordination was required among government agencies, including with help of DOJ and OMB, but also there was a felt need for clarity from the court to understand exactly what the agencies needed to do to comply.
Did they get any clarity in that case? Or is that a matter of some debate?
I think it was stayed fairly quickly.
Some of these issues are obviously high profile matters that got to the White House. And did your investigation include trying to find out what role, if any, the White House had in the implementation of these orders, or was that not part of your investigation?
I don't think it was part of our investigation, no.
We did hear from agencies that how high profile a matter was might affect how the agency operated internally. And as you say, some of these were high profile, but some, although very important to the policy or program officers in individual agencies, were what I would call not high profile, that we saw a wide range. And so the profile might, for example, affect the role of DOJ or the need to coordinate. We did have at least one agency mention coordination with the White House counsel's office. So there may be some effect in terms of the profile of the issue. Might also affect the agency's decision around whether to appeal one of these orders or to go back to the drawing board.
Right. Yeah, I think that it did come up once or twice, at least in their response, in the sense that yeah, do we just kind of like let the order stand and then we'll revisit the rule itself, or do we fight the order? But I guess one other theme that I wanted just to highlight from the qualitative section too, that is relevant to this, is that there was relatively little, like, it didn't really sense much effort at all to behave strategically or evade in any sense the orders. That is, like, all of the conversations we had with agency officials reflected an earnest effort to comply with the orders, and you know, often when they were creating a lot of difficulties in some cases for the agencies. So I just wanted to highlight that as a theme that really carried through a lot of our discussions.
Neil, maybe this is in your bailiwick. Was there any sense, and I think it was mentioned earlier, about the possible, I'll call downstream effects of these orders on how the agency conducts its business, not with respect to the order at issue in a particular case, but how they think about what they're going to do and how they're going to frame their rules going forward?
Yeah, so we did talk about that with interviewees, and I'd say most of them said this, you know, the issuance of such orders and their increase in frequency it hasn't really significantly affected what we do as agencies in pursuing our policy goals. So as one put it, we don't plan on losing. The driver of our regulatory activity is not the possibility of an injunction. And interviews emphasize that agencies are sensitive to litigation risk generally, not to orders with universal effect as a remedy in particular. Some of our interviewees noted that the increased litigation risk did lead them to be more careful in their rulemaking processes. So one interviewee noted that we have an interest in the structure of the remedy in a sense that we only want to have vacated what we need to have vacated, right? So the vacator that should not affect more portions of the rule than are actually found to be unsound. But as that suggests, the focus of the agency is on crafting rules that can withstand legal challenge and limiting the scope of the adverse ruling on the rule rather than limiting the scope on a universal / non-universal basis. And there was one executive agency official that did comment that the rise of these remedies affects agency thought processes all the time when the agency is assessing policy. And that agency official commented that in their perception, agencies are facing much more judicial scrutiny now than in the past, and the officials speculated that agencies might be inclined to pursue enforcement actions or adjudications rather than rulemakings, though they presented this as a hypothetical response rather than as a current practice.
We've seen a lot of negative comments about national injunctions, but I want to flip it around and ask the other way. What happens if we don't have national injunctions and the agencies are in a situation where one court says they can go ahead and another court says they can't, and a third court says you can do some of this and others? Is that a problem for agencies? And did you talk to them about that, the opposite situation?
Yeah. So just to begin with, when we asked about, like orders that were limited to the state or the district or to just particular plaintiffs, one thing we heard as an initial matter was that officials were unfamiliar with the idea or with the concept of geographically or party limited vacatur of rules. That was kind of caused they kind of expressed unfamiliarity and confusion at the idea that of non-universal vacatur and uncertainty about how they would respond to limited vacatur. And several of them told us that non-universal orders could cause significant difficulties in implementation. Some noted that nationwide injunctions might actually be less complex to implement than remedies that applied only in certain geographical areas or to certain parties, because non-universal relief of that kind would create a patchwork of regulations that would pose regulatory challenges and be, as one put it, very difficult to implement. Now, that was what most told us. There was at least one official who noted that it would be more complicated, but it would at least allow the agency to continue to pursue its goals in unaffected areas, and that they also noted that plaintiff-specific injunctions may, in some cases, be easier to implement because the agency then knows a particular party that is protected from that particular rule.
So I want to talk about the particular party aspect because that I remember there was a case, and I can't remember exactly what it was. I think it was somebody who didn't want to wear a mask on an airplane, and there was a nationwide injunction, or at least an area injunction about that, and that person could have been given individual relief, and that would have presented much fewer problems of implementation. but a national injunction would have, on the other hand, made it same for everybody.
I think this connects, and I sorry to keep repeating it, but because it was really central to our findings are these questions around clarity. And some of the issues of clarity, I think, go to the judge, and the judicial decision is unclear. But many times it's really a kind of an interaction between the court and the agency, that there is no way for the judge to understand how a regulatory program is implemented, whether individual state-based or universal relief would be more or less problematic unless the agency through counsel presents that information. So I think when we heard that agencies were briefing the scope of relief, I think one thing that included or should include is giving the courts a fuller understanding of what it would look like for an agency to implement different types of relief. Again,
Options.
right. And it may be, as you say, that there are some types of agency actions for which individual relief is quite easy to do, and others where it would present additional complications, others where the unfairness between implementing a regulation on one party and not another, we heard this theme from agencies as well, treating like cases unalike presents fairness problems that run counter to the mission of the agency.
Jed, I think you were going to talk about next steps and further investigation. Is that right?
Yeah. I mean, the way I was thinking about the next steps and we thought about it a little bit is that there are two main non-findings from the research, and these are non-findings that are notable because we went into the study in a lot of ways expecting to find these things, and we didn't. So it's the Sherlock Holmes dog didn't bark a little bit kind of finding. So one thesis we had going into this was that agencies are going to adjust their behavior if these are consequential forms of remedies for them. And in no real instance did we find agencies reporting that it significantly affected their behavior in anticipation of the possibility of nationwide injunctions. So they were not substantially changing the content of rules or shifting into alternative policymaking forms, which is a thesis that would be which was one of our main theses going in. A second thesis was that that the compliance problems were both going to be in terms of the nuts and bolts of compliance were going to be difficult for agencies, and that too we didn't hear a great deal from agencies on. So those are both non-findings, and so one next step or one open question essentially is, well, are these short-term results, or instead are these really an enduring feature of the way agencies will be interacting with nationwide injunctions, assuming that nationwide injunctions are an enduring feature of the litigation landscape? So those are kind of non-finding questions, a temporal question about how transitory are our non-findings. Then we had two kind of findings that I think both call for two positive findings, both calling for I think further research and study. One is the one that Zach and Mila have talked about throughout their discussions too, which is this clarity issue. So a study focused on the clarity of the orders. What are the features of the orders that make them unclear and difficult to implement, like in a broader sense? This is something we touched on only sort of opportunistically and episodically, depending on the course of our interviews. But a focused study on clarity itself, I think, would be revealing. And then how could they be more clear? And so some of your comments went to this too. Maybe there's more dialogue with DOJ and the like that would help clarity of the orders. There's also possibility for sort of quantitative and experimental research in this way. So using experiments to try to figure out, what do agencies find clear or not clear? The second study, sorry, go ahead.
No, I thought you were done. Please.
No, well, just one more kind of thought that we had was that some of the agencies we talked to had channeling statutes that affected how their cases were brought up, and those bear some relationship with nationwide injunctions, and they seemed quite they seemed quite comfortable with the idea of channeling statutes. And there's a question of like, well, can channeling statutes substitute in some, get some of the benefits from nationwide injunctions without some of their challenges. And so that was another study is to think more about channeling statutes and should they be expanded to cover more agencies.
And Jed, could you tell, is that because the channeling statutes take cases to almost all of them take them to the courts of appeals, where there are 3 judges who are reviewing the challenge rather than to the single district judge, where 1 judge could be entered, perhaps even a preliminary injunction on a nationwide basis?
Yeah, well, I mean, if it goes to a channeling state, I mean, there's both the appellate versus district issue. Then there's just the number of possible entities that could be deciding a case is different in the 2 cases, in the 2 scenarios. And then there's the notions of specialization, with 1 court hearing, litigation with respect to a certain statute occurring repeatedly in a single court could be beneficial. And then, the limitations on forum shopping too. So like, to the extent that forum shopping is a concern with nationwide injunctions, you'd find, picking out the district court judge that you think is going to be sympathetic to you among the many out there, it kind of limits the opportunities for that behavior.
And last related question, were agencies any different in terms of their concern about preliminary injunctive relief versus permanent injunctive relief and their ability to respond, or that was, or is it just nothing there?
We talked about sort of both of those kinds, and that wasn't like a change. I mean, a difference that really seemed to jump out. I mean, the overall, I think, as Zach mentioned, like the overall message that we got overwhelmingly was that agencies were intent on good faith compliance with court orders.
Right. Yeah. So we explored the different types of relief question, the injunction versus vacatur, the preliminary versus permanent. We asked about whether it mattered if there was a certified class or a proposed class action or no class action. And really none of these distinctions seem to matter. Another one that agencies said did not matter is between different courts. So although the DC Circuit certainly has a reputation of being an important body in administrative law, that most of the interview subjects said when a judge tells us to do something, we do it. We don't look and see if they're, D or R, if they're in one state or another. Really, this good faith compliance was overwhelming in our interviews.
And other than the fact that there are more of these, does the increase in number of these national injunctions signify anything specific, or does it suggest that we need to do something, or does it suggest that there just need to be more of these cases where the agency has to proceed as it's always proceeded when it's got subject to an injunction? Should we be worried about the increase, in other words? Or didn't your research answer that question? That's a normative question that the people who are making the laws, because just my reaction when I read your report and hearing you today is that agencies are doing what we hope they would always do, which is to comply with what the judge says and figure out a way to get it done and proceed before carrying out their mission. Yes, we have more of these that are problematic, and maybe we have to think about that. But the world is not going to, Earth is not going to stop rotating, and the agencies are going to still continue to do what they've always done. Is that a fair statement, or am I being too Pollyannic?
Well,
I think it's certainly. Sorry, go ahead, Mila.
Oh, go ahead, please.
I was going to say that is certainly consistent with what the agencies told us, that they're in this to do policy work, and they're going to try to make good policy, and they're going to respond to the litigation environment as it plays out. They are sensitive to litigation risk. So, to the extent we want to make normative judgments, I think the question might be whether the dial is turned up too high or too low in terms of litigation risk generally, rather than a question again about kind of scope of relief.
Yeah, I would just put in 2 quick caveats. The first is that so what Zach said is exactly what came out from the report and in our interviews. I think there are potentially, we just have to be acknowledged that there are potentially some limits to the interviews themselves. That is, like, we did give anonymity and promised confidentiality, but we never know like what's the full story. We're also looking at talking just a sample of agency officials that could be playing out elsewhere in different parts of the agency. And the second point, just again to return to one of our conclusions, is that it's not totally clear, because of the recency of the rise of nationwide injunctions, not totally clear if what we're seeing in it is the long run effect of nationwide injunctions, or instead just a short-term non-finding, essentially.
All right, I think we have an opportunity for questions from the audience. Kazi, do we have some questions that we're ready for?
Yes, we put one in the chat to you from Bill Funk, which you can also see in the Q&A.
Let me see, where's my chat function? All right. Bill Funk asked whether the rise in universal injunctions is a function of more rules being challenged and found unlawful. His sense is that rules challenged on a pre-enforcement basis have always been vacated or enjoined universally. Any sense about that?
Yeah, so this, I mean, speaking personally, I have done scholarship in this area, and I do think that there is a very robust record of pre-enforced rules being challenged on a pre-enforcement basis being vacated or enjoined universally, and I think that is accurate, that graph, the uptick that we see on that graph is about reflects an increase in the number of suits. However, that is not something that we examined in our work. Like, it's not like we went through and looked at quantities of complaints being filed over time, right? Our empirical quantitative analysis didn't like scour dockets for complaints and then say there's been an uptick in the complaints. All we can see is the uptick in the final order.
I think that's right. Just the one amendment to that is that we can ask the question. We did not directly investigate that, but based on our findings, we can ask the question: what would we have to believe about the sort of the rate of rules being challenged generally to think that the uptick we see is a result just of litigation generally increasing? And if you look at the figures, for instance, there's during Trump administration approaching 30 per year injunctions granted. During the Clinton administration, we're talking about 1 or 2. So if you think that the rate of litigation or the rate of rules being challenged generally is 30 times now what it was during the Clinton administration, then this is a kind of theory that I think would be worth thinking about more closely. But if those rates, if it doesn't seem like litigation rates generally have increased by 30 times since Clinton administration, it seems like there's been just a separate increase of nationwide injunctions apart from rules generally being challenged.
So I wonder whether many of these rules were challenged and were successful in the past, but instead of issuing a nationwide injunction, the judge just said the rule was invalid. The agency took an appeal or didn't take an appeal, and the case went forward. But it's the boldness, if I may, maybe it's slightly overstated, or perhaps it's just the clarity of the effect, and it eliminates the issue about unfairness, because we're saying that the judge is now saying everybody's is no longer subject to this rule. Whether that change is really more of a indication in the change in numbers, rather than the fact that many more rules are being held to be unlawful than they were held to be unlawful in prior administrations.
So you asked,
that?
Yeah, you asked earlier, Ellen, about the kind of choice of relief question, and something that we didn't say at the time, but I think is also responsive to what you just said, is another thing that was not investigated in this study was litigation strategy on the part of plaintiffs. We're talking about the defendants, but it's not the defendants or even the judge sua sponte who is suggesting injunctive or APA relief. That's a question about how the complaint is styled. And so maybe the effect that we're seeing is a change in litigation strategy on the part of plaintiffs, more frequently seeking injunctive relief as compared to seeking vacatur. That also could change what's going on, the same pool of cases, but pleaded in a different way. But that was just beyond the scope of our project that focused again on how the agencies understood what's happening. But I hope someone out there is conducting interviews with plaintiffs in state AG offices and law firms around the country, because I'm curious about the answer to this question too.
Well, you mentioned state AGs. Is there, in my experience, state AGs bringing the kind of challenges that have been seen, particularly in the Biden administration, but there were a fair number, of course, in the Trump administration as well. Not necessarily of rules, because sometimes the Trump administration issued orders that look like rules, but they were not styled as rules. For the Muslim ban, for example, could have been called a rule, but it wasn't issued in that form. And so I wonder if that's a factor as well. All right. Kaji, we have more questions in the chat. I don't see any other ones in the chat right now.
No, I think those were all the questions we had.
Do any of our panelists have any further thoughts they want to put out? Okay, I think we'll yield back the time. Like a good oral argument. If you don't have anything further to say, don't say anything further. Don't stand up and rebuttal unless you're really ready for it. So, okay. Andy, you want to chime in with your final words, and we'll let people go back, get a few extra minutes on a Friday afternoon.
Yeah, thanks so much, Alan, and thank you to everyone for an excellent discussion of a very important study and findings. So thank you, Alan and Mila and Jed and Zach, and of course all of our viewers. I hope you found it informative and entertaining as well. Our next forum in this two-part, or our next panel in this two-part forum will be next week on Wednesday, October 2nd at 12 o'clock this time. Today's was 12:15. Next week is 12 o'clock until 1:15. You can register for that forum on our website, acus.gov. And a link to the entire forum has been placed in the chat as well if you need that. While you're on the website, please look around and learn more about what we do, what we're working on, what products are available to you that we hope will help you in your work. And while you're there, please register for our newsletter, which you'll get regularly, updating you on what we're working on currently and what you can expect from us in coming weeks and months. So that said, that's it. Thank you, and we'll see you next time. Goodbye, everyone.
Bye. Thanks, Andy.